Ron is the attorney for the plaintiff in the Cardi B case. Ron had an interesting trial strategy. Ron was accused during trial of arguing facts not in evidence during closing, which he objectively did because we watched that happen. At the end of the Cardi B trial, the court indicated that the court would allow a motion to compel regarding contempt of court and sanctions due to the violation of the court's motions in limine, in addition to the arguing facts not in evidence at closing. It happened multiple times. And then the attorney for plaintiff in that case spun out in the wildest way. And not only did he spin out, but he spun out and argued, I can't fully defend myself. I have a lawyer. That lawyer never appeared or filed anything. He argued that he is an inexperienced, unseasoned lawyer, that he has only been practicing for 21 plus years, that he has only done like 10 or so trials, and that he just didn't know any better, and that his law license is the most important thing to him, and that the court is the prettiest judge he's ever been before. I'm adding that part. Everything else is not hyperbolic. And that he would never willfully violate the court orders, and that he just didn't understand, but also not that he just didn't understand. He didn't understand, but also someone else, his office manager, wrote his questions for him, and he was just reading those questions. And so he didn't mean to violate the court's order, but he didn't understand it was the court's motion to eliminate order, but he didn't even write his questions. Somebody else did. His office manager, who may or may not be a magician. I am not making any of that up. When we were covering this case, I was a bit horrified by the actions and behaviors of this attorney, so I Googled him. And that's when we found that Ron had another case where he was accused of assaulting opposing counsel in the hallway and like putting hands on opposing counsel and like grabbing and spinning opposing counsel and then stomping on his glasses. And that this kerfuffle in the hallway actually caused a mistrial in another case that he was well into trial on. In the motions we're going to look at today, we learn a little bit more about Ron being a menace in the hallway. And for those of you who are like, Emily, a magician, what are you talking about? We'll get there. So in all of the litigation for this, Ron was evading service. Ron was like, nope, you can't touch this, and was not able to be served. We are going to go take a look at some of the evasion of service of process because the notes from the process server are funny. That's why we're looking at them. And then we are going to look at the court's order from the very end of last month regarding the contempt. We are looking at the ex parte application for an order regarding service. Your Honor, deem him served. This is from November 5th, 2025. On October 20th, 2025, the court granted the application of defendant Cardi B for an order directing Ron, his name's Rosen, counsel for plaintiff to show cause why he should not be sanctioned or held in contempt for trial misconduct. While the court's order to show cause, the OSC, bears an October 20th, 2025 filed stamp, it was not provided to the certified electronic service provider, One Legal, and in turn provided to defendant's counsel until 5:08 p.m. October 27th. So there was a delay. Nevertheless, defendant promptly sought personal service on Ron. However, as detailed in the attached, Ron has willfully evaded personal service and has failed to respond to the request he accept service. Yet, he has been served by email as he previously demanded in writing and by personal delivery to his office of record and to another address he has used in litigation. He presumably also was served via the court's electronic filing system. Accordingly, defendant respectfully applies for an order deeming him served. Defendant has complied with the OSC requirements of service by email. They talk about serving him by email at the email address that he uses, which is tillybeverlyhills@yahoo.com. Emily, why do you call this out? Because if you are working with counsel, what I want to see is at lawfirmname.com. Defendants' multiple attempts to serve Ron, the office at Wilshire. On October 28, 2025, personal service was attempted on Ron at his office of record, 9025 Wilshire Boulevard, Suite 304. The 9025 Wilshire Boulevard, Suite 304 address is the same address that Mr. Ron used in his pleadings in this action, listed as his address and email for service in this matter, and maintained as his office address of record with the California State Bar. However, no one was present at the office address. On October 28th, 2025, personal service was again attempted at Mr. Ron's purported address for record in this matter. The process server was met by a person claiming to be a magician who stated that the office is his own and that Ron was not there and that he only accepts deliveries for Ron. I am not making that up. On October 29th, public records checks revealed that Ron is affiliated with a different suite location, which is a different office in the same building, which is found to be occupied by a magician. Service was attempted at the other suite. That suite was used as a shipping office. None of them knew who Ron was. But a staff member in the building said that Ron receives mail at the 304 address, but has not been a tenant in over 15 years. Do we know why he's not been a tenant for over 15 years? We do. This is from October 28th at 2:25 p.m. Office 304 has a sign on the wall for Ron. He needs to call him before accepting any deliveries. Michael is a magician. He runs Gilmore Fegan Community Development Cooperation and Fantastic Fig Magician. Ron only receives mail there. Those are the notes from service of process. And then they go up to Suite 304, the one that's listed by the California Bar. I went up to the third floor to take a picture of Suite 304 and noticed they had taken down their information off the wall. So Ron's info was on the wall the day before. The next day, the plaque is off the wall. No Ron. The janitor was in the hallway and I showed him Ron's picture. And he said that he had been kicked out about 15 years back for an altercation they had regarding his motor vehicle case. He said that Ron threw $1,000 at him in the hallway and yelled at him. And since they have cameras, he told the landlord and had him kicked out, but he still received mail over at Suite 304. Because even 15 years hence, he is a fucking menace in the hallway. So not only is his office literally occupied by a magician, they try to serve him with court papers at his office that is listed for the California State Bar. And then he takes his name off the wall. Like they're not going to find you. He takes his name off the wall. And then the janitor just happens to be there saying, oh, that guy? He got kicked out for verbally assaulting me in the hallway. Why is he still allowed to collect packages there? So the magician collects packages for him, but doesn't accept service of process. You have to have a valid address for service of process. You're a lawyer and got kicked out of the building because he attacked the janitor in the hallway, which tracks with all of his other behavior. This dude is a menace. Ruling on submitted matter in contempt hearing, Ron. Motion in limine regarding prior bad acts. The motions in limine were heard at the time of the final status conference, including the defense motion captured, quote, motion in limine number 1 to exclude evidence of alleged prior bad acts by defendant. Among the various bad acts sought to be excluded by defendant Cardi B was any alleged, quote, former association with a gang or gang members during her youth. The court issued the following tentative ruling on the motion. Granted, subject to defendant not opening the door. Fair. If somehow the defense opens the door and it becomes relevant, then it can come in. Fair. Ron was seeking it to try to say a person that does this is likely to do this. That's the argument he was trying to make. It's improper. It's trying to tarnish someone's character. It's trying to show conformity to act therewith. And it doesn't even logically make sense. During the trial, Ron asked the following question. Question, do you have any affiliation at this time with a gang? The court promptly sustained defendant's objection to the question and cautioned Ron about the clear violation of the court's ruling on the motion. He argued, first, that he didn't write the questions. Second, that he didn't violate the court's ruling. And third, that the court's ruling was limited to past gang association, not current gang association. So, Your Honor, I didn't violate your order. You said past affiliation. I asked about now. Prior to closing arguments, Ron requested that the court take judicial notice of certain facts. The court denied. After the court ruled, the following dialogue took place. Ron, I want to be clear that I intend to argue in my closing. The court, it's not in evidence though. The court continued. I think it's readily apparent that you can't argue facts that aren't in evidence. Right. And the plaintiff counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. During a later discussion, Ron confirmed his understanding of the scope of closing argument. Ron, I feel that what counsel has just stated is really below the belt and disrespectful to my side. We watched this. We watched this happen. I feel what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside the evidence. Despite the court's clear expression of its expectations and despite Ron's clear understanding of the expectations, he repeatedly referenced evidence that was not introduced during the trial. The court sustained defense counsel's repeated objections, but did not issue a warning to counsel that further references to evidence not admitted during trial would be subject to a finding of contempt. And that, friends, is the problem. When the court goes through the law, the court is limited in the type of contempt he can find Ron in because the court did not warn him that it was contemptuous behavior. And that limited how much the court could do in this case. And that is incredibly frustrating to me. I am sure the court was so frustrated in this moment that the court didn't even think about it because it's so rare that you actually have to hold someone in contempt that the court wasn't even thinking because it's in the middle of closing arguments. And it is so out of left field that an attorney would so willfully violate the rules that I truly don't think the court was even thinking. Like, I need to warn him that he's going to be held in contempt for this. You have to tell them. And I don't think defense counsel in the middle of closings is like, Your Honor, can you advise counsel that he could be held in contempt? But that closes the door to most of what the court can do. So the bigger contempt finding the court is forestalled from. The court can only sanction for the violation of court orders, cannot hold him in contempt because he was not warned that he would be held in contempt. And the court says, Civil Code 1209A5 states that disobedience of any lawful judgment, order, or process of the court constitutes a contempt of authority of the court. However, absent particularly egregious behavior, which I think this is, the trial court must first warn an attorney of the contemptuous nature of the courtroom conduct before initiating contempt proceedings for a subsequent violation. Here, the court sustained the objection relating to the violation of the in limine ruling, and he did not repeat the conduct. While the court did sustain objections to the repeated references of facts that were not admitted during the trial, the court did not issue a specific warning. As such, the court finds that this record does not support punitive sanctions under Section 1209. However, Code of Civil Procedure 177.5 does provide the court with the power to impose reasonable monetary sanctions for any violations of a lawful court order done without good cause or substantial justification. The court further finds that he acted without good cause or substantial justification in violating this lawful order and imposes sanctions on Ron in the sum of $1,500 payable to the court within 30 days. That means he then has to report himself to the state bar. The clerk of court is ordered to provide the notice of this order to the state bar. He is reminded of his obligation to also report himself to the state bar, and this will go to the state bar. He is required to pay within 30 days of January 28th. We have not exceeded that 30 days yet. I have not seen notice that he's paid. $1,500 are the sanctions imposed because the court could not hold him in contempt under the other code section because the court did not warn him that a further reference to facts not in evidence in closing would be contemptible. The Ron situation is frustrating to me because it was clearly contemptible behavior, but procedurally, the court is required to warn the attorney that further violations could result in contempt. And because that ruling was not made, because that warning was not given, the court could not find punitive contempt, which are the higher levels of contempt and higher sanctions. So the court went with reasonable, reportable to the state bar sanctions under a different code section. So yes, the court found that Ron's behavior was contemptible, that he violated court orders, that he misled the court, that his behavior was improper, and this entire order is going to go to the state bar. And when this happens in the future and other lawyers have him in the case, they can go find this order and know to ask the court, Your Honor, you need to warn counsel that further violations, he'll be held in contempt. But $1,500 means he just has to report himself to the state bar and pay the fine. And it's infuriating, isn't it? Because we watched it happen in real time. It should, though, be a warning to clients and future clients that this is not an attorney who is in good standing with numerous courts across the county and who has mucked up cases that we have seen with this type of behavior. And if you are looking at a trial case, an attorney that is filing signed motions under penalty of perjury saying, I'm just not a trial lawyer, Your Honor. I just don't know what I'm doing. I don't know the rules. I'm unseasoned, is something to be considered. Ron was sanctioned $1,500 and has to report himself to the state bar. The court listed out in numerous pages all of the violations. So hopefully next time, this will not happen. He has been sanctioned much more substantial amounts in other cases for discovery violations. And I think the bench in Los Angeles is probably aware of who this attorney is at this point and aware that he is a purported menace in the hallways. I will be interested to see if he was avoiding service, which you are not allowed to do as an attorney, makes its way to the state bar. I would imagine, and this is speculation on my end, I would imagine that opposing counsel will let the state bar know that this address seems to be the wrong one and how much money they had to spend to try to serve him, because it is a problem. So, unfortunately for now, that's the end of the Ron saga. They're not going to get an appeal on this case. Cardi B is not going to have to continue to go to court on this. So at this point, we're done with Ron. In this case, I'm keeping an eye on that other case because now it's got my attention. Remember, the case that got mistried because of the hallway altercation, it's going back to trial later this year. So I'm keeping an eye on that as well. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.